Hello, everyone. Welcome to this week's My HR Minute webinar. I apologize for the late start. We're just having some technical difficulties here, but hopefully everyone can see our slides and hear the audio, and we can get started with the webinar. This week's webinar is on employee travel, compensation, and liability. I am Britt Waterman. I am one of the senior attorneys here at My HR Council, and can go ahead and get started here. I hope we can advance the slides so you can see here. Great. So we can move on to the next slide. So let's talk about travel time. The Department of Labor has issued official guidance as to when travel time is compensable under the Fair Labor Standards Act. This has been a settled matter for quite some time. So reimbursing for mileage and paying for time spent traveling are two completely separate things. In some states, reimbursing for mileage is required, but compensability of travel time is the subject of federal law. So you cannot offer your employees a high mileage reimbursement rate instead of paying at least minimum wage for all hours spent in compensable travel time. You can offer it separately, but it's not the same thing. So if you notify your employees beforehand, you can pay minimum wage for travel time. Otherwise, it is their usual hourly rate. Compensable travel time hours count towards the 40-hour threshold or your state threshold for overtime calculation purposes. Even as we will get into, an hour riding on a bus can be considered an hour worked for overtime purposes. We can look at the next slide. The Fair Labor Standards Act identifies 4 types of travel and breaks them each down by compensability. We can look at the next slide here. So commuting. So commuting, this applies even when the job site changes. So if you've got construction or outdoor maintenance workers who commute to a different physical location every day, they're still going for their residence to the job site, which although it's necessary, it's not compensable. Likewise, mileage for a commute in states that don't require, or in states that require mileage reimbursement, mileage for a commute is not reimbursable. There's nothing that says you can't pay employees for the commute, but you don't have to do it. If you direct the employee to drive and the employee doesn't have the choice of getting a ride or taking the bus or using Uber, then their time spent driving is compensable. You've just made the employee use their time for your benefit, and that's the root of compensable time. Carpooling with another employee does not mean compensable time necessarily if it's voluntary and it benefits both employees. We can look at the next slide. So all in a day's work, employees with multiple job sites, like construction that move from job site to job site, or in-home care providers, are paid for the time it takes them to get between the places on their assigned stops that day. Having everybody show up at the office to meet and then travel to a hotel for a conference, that travel time is compensable time. If you send your employees to help out at another branch during the same day, that travel time from branch to branch is compensable. If you send your employee to Office Max on their way to work, technically their day starts at Office Max and the travel from Office Max to the office is compensable. Let your employees clock in when they start doing something for you. If you send them on an errand, do not clock them out for the travel part of the errand. Doing some work at home before the commute does not make the commute compensable. But a remote worker, someone who is solely working remotely, if they come into the office for a meeting, that is traveling between job sites. So this all comes down to nickel and diming employees. It's the worst thing you can do. If it just takes one complaint and then the DOL is going to come in and add up all of those nickel and dimes from all of your employees over the past 3 years. So if an employee is coming or going for your benefit, you need to pay them. We can look at the next slide for one-day special assignment in another city. So this is travel where the employee returns home the same day. Um, all of the traveling time spent both to and from, and we'll look at the small exception, is compensable, whether driving, bus, train, Uber, etc. How far does another city have to be? The Department of Labor says away from the home community. The Department of Labor also says reasonable commuting distance is 1 hour. So it could mean outside of 1 hour. So for example, I'm based in Minneapolis. People in greater Minnesota outside of Minneapolis refer to the whole 7-county area surrounding Minneapolis as the cities, or we generally call it here the metro area. So it could take me 45 minutes to drive from my home to a suburban conference center and to do training one day. But within that area is generally considered my home community, and my travel time would probably not be compensable. It would be a commute. If I'm going to Duluth, Rochester, these are separate communities that are 2 hours away from my home base here in Minneapolis. That would be more like a one-day special assignment in another city. The Department of Labor's example is going from Washington, D.C. to New York City. That's a little farther, but there is rail transit that makes that commute, or that not a commute, makes that travel time a lot quicker. But basically, it's outside of your home community. It really doesn't have to be that far, but it's anywhere outside of the home community. If it normally takes your employee 10 minutes to get to work and 10 minutes to get home again, you can subtract 20 minutes from the total travel time in this case. But again, you got to watch out for nickel and diming. It will get you into trouble, but you can subtract the time of the regular commute. So we can move on to the next slide and look at overnight travel. Of course, now if the employee is performing work at any time, doing actual work, you must pay for all work performed regardless of when it happens. But the time spent traveling that falls within employees' normal work hours is compensable. And this involves work hours even on a non-work day. So if an employee's work schedule is Monday through Friday, 9 to 5, and the employee is on a plane back from a conference from 3 to 7 p.m. on a Saturday, you must pay them from 3 to 5 p.m. on that Saturday. If the employee does not have a regular work schedule, you have options. If the employee's work hours in the most recent month of employment show typical work hours, use those typical work hours. You can choose average start and end times. Again, be careful with this. You and the employee can negotiate a reasonable time frame during which travel outside of the home community is compensable. You need to have a written waiver of this. If you negotiate the travel time with the employee, you need something signed by the employee saying you agree on it. Once the employee gets to the hotel, travel between the hotel and the conference center is normal commuting time, and that is not compensable. We can move on to the next slide and look at liability, workers' compensation during travel. So any injury that occurs during travel for the employer is covered by workers' compensation. If the injury occurs on compensable time, it will be covered by workers' compensation. If your employee is running an errand for you and a drunk driver T-bones your employee, you must report this to your workers' comp carrier, and that's how your employee is going to get paid for their injuries. If your employee goes to the hospital as a result of this accident, you have to report it to OSHA. Remember, if you attended the workers' comp webinar, if you tell employees to pick up bagels for the meeting and they get injured going out of their way to the bagel shop, that's a detour, that's covered by workers' compensation, that's compensable time. If the employee decides to go out of the way to get themselves Starbucks and gets injured going out of the way to Starbucks, that's not covered by workers' compensation, and it's not compensable. If an employee is traveling from job site to job site and goes to Starbucks on the way, if it takes less than 20 minutes, that could be a rest break. You can't require employees to take breaks of fewer than 20 minutes unpaid. So watch out if their break takes less than 20 minutes. But as far as clocking them out, that could hit you with the Department of Labor. I guess that's a little bit aside from workers' compensation. If an employee has traveled for business, They would not be in that airport or train station or in that hotel or in that restaurant. Your employees have to eat. If it was not to accomplish your business purpose. That means any injury that happens there is a workers' compensation injury. Your employee slips and falls while walking past the hotel ice machine, workers' compensation. If your employee chooses the most expensive restaurant in the city where the conference is and her hair catches on fire when a server screws up the baked Alaska, that's workers' compensation. Even though you wouldn't have chosen that restaurant for the employee, it's still a workers' compensation injury. However, if the employee has a friend who lives in the city where they're traveling to and decides to go on an outing with a friend, that becomes personal, and any injury is no longer a workers' compensation injury in the place because she's in there for personal reasons and not just to serve your business purpose. We can go on to the next slide here. Personal and company vehicle use, you cannot require an employee to accept all fault or liability that comes with driving either a personal or company vehicle or a rental vehicle for business use. You want them to be insured on their personal vehicle, so their insurance is primary. But in the case of a big dollar accident, your insurance will become secondary when their policy hits its limit. You can set the amount of coverage you require them to have, so it's less likely that an accident victim is going to reach your pockets. You must have a driving policy. It should include things like no use of mobile devices while driving, no non-employee passengers. Employees are responsible for parking and traffic tickets. Employees must follow all traffic laws, report accidents to police, report any moving violations or accidents, changes to their own driver's license status or insurability. All these things are important. If you have employees using vehicles as part of their job, you should have a driving policy. We can move on to the next slide, travel reimbursement. So if you do travel reimbursement, you should have a travel reimbursement policy, and you should also make sure you have an accountable plan under IRS regulations. So an accountable plan is a plan that requires employees to document expenses and to return any money that you pay them that they cannot support with documentations. So this is what you want, because this way none of the funds that you pay them for reimbursement are going to count as wage income or create payroll tax liability. If you're letting them submit expenses that they can't document, that's going to count as wage income, and that's going to create payroll tax liability for you. So there are 3 requirements: business connection. You only pay for business expenses while performing services for the company. This is why your policy should say nothing personal, no haircuts, no pay-per-view movies in the hotel. If the employee uses a personal vehicle for both business and personal use, you will only reimburse the business portion. Paying non-business expenses such as buying lunches, those are treated as expenses from a non-accountable plan, but just doing that once in a while does not make the whole plan non-accountable. Adequate substantiation, the IRS has published guidance for what is appropriate documentation, and you can find that IRS guidance online. They have guidelines for what is an acceptable time to provide that documentation. The IRS says 60 days is automatically appropriate, requiring employees to provide documentation within 60 days. The IRS doesn't require a physical receipt for all expenses, but it is best practices to get a receipt for your employees to substantiate any expenses that you're going to reimburse. Return of excess reimbursement. If you pay for travel or other items in advance, the employee has to pay back the difference if it turns out to be less than what you've advanced them. Again, the IRS says for them to pay it back within 120 days is reasonable if your plan prohibits making advances more than 30 days before the expense. So you don't want to advance money more than 30 days before they're actually going to incur the expense to keep in line with the IRS guidelines. So that is our webinar today on travel compensation and liability. If you would like more information or you have specific questions, if you are a client, you can open a ticket in our Ask an Attorney portal. If you are not a client and this is something that you would like more information on, you can get more information on matters like this or other unlimited HR and employment law advice by signing up for our services at myhrcouncil.com, or you can ask questions at info@myhrcouncil.com if you would like a demo or like to learn more about our packages. So that concludes today's webinar. Again, info@myhrcouncil.com for any questions, or if you are a client, please open a ticket in our Ask an Attorney portal and we can answer any questions you might have. So thank you all for participating in the webinar today, and I hope you all enjoy the rest of your day.